My name is Dakota Flint, 47, structural engineer, divorced. I inherited 47 acres in Colorado from my grandfather, William Flint. He bought the land in 1971 for $8,200 cash. I have kept the chain intact by paying county property taxes, $6,400 annually every year since I inherited. The receipts exist and the county records match. There are no gaps, no silence, and no abandonment. In August 2022, after 3 years away, I drove to the same coordinates to honor my grandfather and found a finished subdivision. The carved entrance read, Ridgeline Heights. Paved roads, streetlights, and cul-de-sacs framed 96 stucco houses marketed around $485,000 each. Moving trucks idled while families carried furniture inside. At the gatehouse, a security guard refused me entry. Cassandra Whitmore, the HOA president, arrived and dismissed my deed as irrelevant. She asserted the land was abandoned, cited Colorado adverse possession, and said her lawyer had confirmed the development's position. She claimed $16 million in pre-sales, photographed my license plate, threatened to call the sheriff, and told me to leave. The dispute was now clearly framed. A recorded tax-paid deed versus an HOA developer claim of abandonment and adverse possession, with construction already complete. I answered with records, not argument. At my kitchen table, I laid out the 1971 deed, the survey maps, and each tax payment since inheritance. I called Cassandra's attorney and reached a receptionist who conveyed an offer. $15,000 if I signed a quitclaim deed by Friday. A quitclaim would surrender whatever rights I hold without any admission that the other side owns them. I declined the nuisance money and resolved to seek serious counsel. The facts in view remained narrow and weighted. The property was not abandoned. Taxes were timely. The subdivision rose on the same coordinates. Cassandra's position is recorded. Abandonment asserted. Adverse possession invoked, sales ongoing, and enforcement threats made. My position is recorded. Deed in hand, taxes paid, and a refusal to relinquish title for a nominal payment. For the moment, I make no public statement. I document, preserve, and plan to proceed deliberately. Find counsel, continue gathering proof, and allow a complete evidentiary record to form before litigation begins. Dakota retained attorney Lydia Chen with one objective: convert facts into leverage without inflaming collateral damage. In their first meeting, he placed the 1971 deed, survey maps, and the full stack of paid tax receipts on her desk. She reviewed statute and timeline carefully, then summarized the threshold issue. Colorado adverse possession requires long, continuous, hostile occupation plus tax payment by the possessor. Here, the owner paid the taxes, so the claim, in her phrasing, was stillborn. He asked whether an immediate injunction should stop work. She proposed the opposite: allow completion, then file for declaratory judgment and damages grounded in a complete dated record. Her reasoning was strictly practical. If construction halted midstream, bankruptcy could strand 96 families and shift the fight into a prolonged tangle with lenders, insurers, and buyers. If completion continued under notice of dispute, the finished inventory would crystallize damages and expose the developer's risk calculations. Her instruction was simple: do not engage publicly, collect evidence, preserve surprise, and file once the record is mature. He signed the retainer and began a disciplined routine. From a lawful shoulder on the public road, he filmed dates, times, crews, and deliveries. He logged plate numbers, contractor names on truck doors, and daily progress photographs. Deputy Torres approached once after a complaint, verified he was on public right-of-way, and cautioned both sides to keep interactions civil. Families started moving in as closings occurred. He noted that buyers appeared to be ordinary purchasers who believed their documents. The project kept advancing. His log kept growing. A certified letter soon arrived from the HOA side accusing him of harassment and trespass and threatening litigation if he continued surveillance. He delivered the packet to Lydia. Her response was clinical. This was proof the developer and association had actual notice of a dispute while sales and construction continued. She told him to maintain the routine and avoid commentary. The posture was now set for January. Permit records gathered, correspondence preserved, photos and videos chronologically indexed, and a clear plan to seek declaratory relief, damages for trespass and unjust enrichment, and any additional remedies. Supported by the papers, the instruction did not change. Do nothing publicly. Let them finish, then litigate. The next phase moved from cameras to clerks' offices. Dakota searched Boulder County's online dockets, permit indices, and assessor rolls, and state business registries. He confirmed the development entity as Whitmore Development LLC, a Delaware registration managed by Cassandra Whitmore, and the financing arm as Ridgeline Capital Group in Denver, with Preston Whitmore listed as a principal. Prior civil matters tied to Preston appeared as construction defect and investor fraud matters, reportedly settled. County permit files identified the parcel as formerly tax delinquent, with an adverse possession filing dated March 2022. The required court judgment quieting title, however, was absent. Despite that absence, lot sales and pre-construction contracts proceeded as though final judgment had issued. Marketing and sale activity commenced without a judicial determination transferring title. While he compiled screenshots, Cassandra's side escalated through local process. Code enforcement received an anonymous complaint accusing Dakota of dumping materials and storing hazardous waste. Inspector Rick Polson met him at the entrance, walked the perimeter, inspected behind newly built homes, and found no violations. Off the record, Polson described a recurring pattern at Whitmore projects, neighbor complaints spiking shortly before or during permitting. He handed Dakota a card, indicating willingness to describe his observations if called. Cassandra noticed Dakota filming again from the road. Another letter threatened a harassment suit if he continued filming. Lydia read the packet and added, "It to the growing evidentiary spine, knowledge plus continuation." They had notice of a dispute yet continued closings and work. The letters in sequence would help rebut any claim that they believed the land was unclaimed. Dakota's logbook added residential context: U-Hauls, utility activations, landscaping, move-ins. He did not interfere. He documented dates, contractor names on trucks, and visible permit stickers. Purpose: establish timeline, occupancy, and enrichment for damages. By month's end, 3 strands aligned. Filings without judgment, sales under, color of those filings, and a complaint-driven cycle that produced no violations. With papers in order, counsel moved to shift the dispute from inboxes to a courtroom calendar. Reputational pressure arrived before pleadings. A Facebook post authored under Cassandra Whitmore's name labeled Dakota a stalker, claimed he photographed children and asserted he was harassing despite clear title. The post displayed his license plate and spread quickly through local groups. Immediate effects followed. Co-workers asked questions, neighbors kept distance, and someone spray-painted pervert on his garage door. He filed a police report and photographed the damage. Pause. No replies online. Screenshots instead. Dakota called Lydia repeatedly. Her guidance did not change. Do not engage publicly. Capture screenshots, preserve links, and prepare an emergency motion for a narrow, enforceable temporary restraining order citing defamation, interference, and intentional infliction of emotional distress. Documentation, not debate, would anchor the response. A new vector appeared. A private investigator, Thomas Brennan of Apex Investigations, approached Dakota's adult son at work, asking insinuating questions about reliability and past conduct. Lydia flagged potential witness tampering and instructed the family to route all contact through counsel. She logged the business card and timing. Shortly after, an IRS audit notice arrived referencing a third-party tip. Lydia prepared subpoenas, aimed at Apex's client records to trace the origin of the referral. Again, the instruction remained: do not react publicly. Expand the record. Throughout, Lydia kept the calendar steady. January filings were approaching. The case would remain grounded in deed, tax receipts, permit chronology, letters, and inspection outcomes. The smear campaigns, while corrosive, functioned as context. Events that would be presented alongside records created by public agencies and licensees. The narrative stayed narrow: who did what, and when. Cassandra's side sent another formal letter threatening litigation for surveillance. Lydia added it to the stack as proof of knowledge and continuation while sales and move-ins accelerated. Dakota maintained the same routine from the public roadway: time-stamped videos, dated photos, simple captions. He slept poorly, told almost no one, and let the file grow. The month closed with two realities side by side: online noise and on-paper evidence. The first rose and fell by day. The second accumulated quietly. Lydia's final instruction before the filings was identical to the first: stay disciplined. Speak only through documents and meet the dispute in court, not in comments. Understood. At the January hearing before Judge Angela Ramirez, defense counsel filed a late motion to dismiss anchored in adverse possession claims. The judge began with a single question: did the titled owner pay the property taxes? The answer, supported by receipts, was yes. Under Colorado statute, the adverse possession theory described could not survive that fact pattern here. Counsel attempted to pivot toward abandonment rhetoric. The court asked for evidence. Lydia kept the frame narrow. This was not about doctrinal ambiguity. It was about intentional fraud documented. She introduced Exhibit A, an internal email dated February 18, 2022, from Preston Whitmore to Cassandra Whitmore. In it, Preston acknowledged that the Flint parcel was not abandoned, that the grandson had been paying taxes, and that an adverse possession action would likely fail in court. The message outlined a plan to file the claim anyway, accelerate permits and sales before challenge, and, if confronted, create enough chaos to force a cheap settlement or build, then bankrupt, and leave title insurers to sort the aftermath. Defense appeared surprised. Lydia explained the email's provenance, produced in discovery via a whistleblower connected to an earlier Aspen project. With Exhibit A on the record, the court denied the motion to dismiss, issued an expedited schedule, and entered a temporary restraining order halting further sales and transfers for Ridgeline Heights, pending resolution of the case. Judge Ramirez then warned Cassandra directly: further social media accusations, anonymous process misuse, or threats would invite contempt. In the corridor afterward, Lydia emphasized what had shifted. The case was no longer a dispute of narratives. Their correspondence established pre-construction knowledge and a calculated risk posture. That narrowed the road ahead. Depositions of Preston, Cassandra, the title company, the lender, and permit-pulling contractors, subpoenaed payment trails, and preservation of subsequent defense letters. The hearing also clarified a public point Dakota maintained throughout: ordinary buyers were not targets. The record pointed at decision-makers and licensees who chose to sell without a judgment-quieting title. That distinction mattered for remedy design and courtroom tone. When the calendar was set, Lydia's closing instruction returned to first principles. Allow the record to mature. Speak in exhibits, not adjectives. Keep timestamps tight and captions literal. The next filings would be weight-bearing, notices for depositions, and a path toward an amended complaint if the discovery map confirmed a repeated pattern across projects. Understood precisely. Lydia organized discovery in 2 phases. Phase Y focused on people and paper. Depositions of Preston and Cassandra Whitmore, the title company officer who greenlit the file, the lender's representative, and contractors tied to permits. Subpoenas targeted communications, underwriting notes, and payment records. Phase 2 contemplated an amended pleading if discovery confirmed a multi-project pattern. Identify prior developments using the same approach, cloudy ownership, aggressive filings, rapid sales, and test whether method and participants overlapped. Preston sat first for deposition. The transcript opened with standard background questions, then turned to the February 18th email. Lydia walked him through recipients, attachments, the acknowledgments about taxes paid, and the bankruptcy contingency. He tried narrow answers, then contradicted prior statements on timing and knowledge. By the 3rd hour, counsel signaled discomfort and asked for breaks. The record reflected hesitation and inconsistency. Afterward, defense floated settlement. Lydia replied with terms aligned to the posture of proof, then returned to subpoenas. Meanwhile, intimidation attempts persisted beyond social posts. Apex investigations reappeared at Dakota's son's workplace. Lydia logged the contact and prepared a notice regarding potential interference with witnesses. Soon after, an IRS audit notice arrived citing a third-party tip. Subpoenas aimed at Apex would test whether the referral originated from the same circle that generated the smear, and the earlier complaint to code enforcement. Each item was cataloged with date, document, and point of contact. Dakota, for his part, kept mapping the site from the public roadway. He matched deliveries to visible lots, tracked occupancy through utility service markers, and attached short captions to each photo. The goal remained strictly evidentiary: sequence, actors, and enrichment. He did not approach residents and did not enter the property. He did not argue online. He filed, he saved, he stacked proof. By month's end, the discovery spine was visible. Email admissions, deposition contradictions, and institutional records tying permit actions to ongoing notice of dispute. Lydia's guidance stayed unchanged: steady, narrow, documentary. The next mile markers were title company testimony, lender files, and contractor calendars. If they aligned with the Aspen-era whistleblowers' materials, Phase 2 would follow with precision and without theatrics. On her whiteboard, Lydia diagrammed dates, emails, permits, and wires, drawing arrows. If the pattern held, a racketeering theory could frame continuity of enterprise and method, placing treble damages on the table. Deliberately, a local real estate blog published the full set of Ridgeline Heights purchase contracts. 96. Priced roughly between $450,000 and $530,000. The headline framed the development as homes built on disputed land. Phones began ringing. Homeowners emailed and called, including Sarah Chen, worried about title insurance positions and the prospect of losing savings. Dakota repeated his consistent position. Buyers acted in good faith, and his aim was accountability for decision-makers rather than eviction of families. Lydia pursued a transparency lane that avoided social platforms. She arranged an interview with Patricia Hughes at Channel 9, an investigative segment to lay out documents cleanly. Cameras recorded the 1971 deed, the sequence of annual tax payments, county permit records, and the February 18th email. The reporter also presented public donation records noting a $50,000 contribution linked to fast-tracked approvals. The segment aired 1 week before trial. Public reaction was immediate: recognition, questions, and institutional responses. The legal calendar did not change. Threat messages followed. One caller declared, "You made the biggest mistake of your life." Lydia archived recordings and timestamps. She reminded Dakota to vary routines and keep doors locked, then returned to filings. The point of the broadcast was not escalation. It was comprehension: show how the paper record formed and why the court, not a comment thread, would resolve ownership and remedies. The broadcast also produced an institutional effect. Sources contacted Lydia's office to confirm details. Records custodians responded faster, and a narrower, document-driven conversation emerged among stakeholders. The plaintiff's message remained unchanged in every venue. Enforce deeded rights, expose the documented scheme, protect families who purchased without knowledge of the dispute, and route misconduct to regulators where appropriate. As trial week approached, Lydia tightened outlines for witnesses and exhibits. She stacked the timeline like a spine: inheritance, taxes, permits, letters, inspection outcomes, the smoking gun email, and the expanding log of intimidation events. She rehearsed narrow phrasing and cautioned against surplus adjectives. The case would move on admissions and dates, not speculation. Cameras could follow. The record would lead. Title insurers paused claims reviews pending court findings, and buyers compared policies against exceptions clauses. In calls, Dakota reiterated he sought remedies targeting decision-makers, not evictions. He emphasized continuity. The same facts, a measured approach as attention widened. 2 days after the broadcast, Dakota returned home and found his front door ajar. Police cleared the residence room by room. Nothing was missing but a single sheet of paper sat on the kitchen table with one sentence in block print: "Drop it or lose everything." He provided a statement and preserved photographs. The report noted there were no signs of forced entry. Pause. The file absorbed another dated event. A neighbor, Carol, shared that she had observed a black Audi SUV near the house the day prior, and had written down the plate number because it seemed out of place. The plate traced to Apex Investigations, the same private investigation firm whose representative had contacted Dakota's son at work. The incident report captured the number, the date, and Carol's note. Without interior footage, attribution remained unresolved, but the pattern of intimidation attempts now had a timeline linking online smear, workplace contact, and a home entry scare. Then the evidentiary center of gravity shifted. Rocky Mountain Title, the file's title company, agreed to cooperate. According to Lydia, they acknowledged internally that the adverse possession clearance was shaky and produced material showing a $45,000 payment connected to Preston Whitmore. The company delivered emails, payment records, and recorded calls. That production placed licensed professionals inside the factual chain and elevated regulatory exposure beyond civil court consequences. Settlement feelers emerged from the defense. Lydia declined them and kept the schedule intact. Trial would consolidate testimony under oath, align documents with dates, and reduce speculation to the edges of the transcript. She organized exhibits to present a simple sequence: deed and taxes, permits and sales without judgment, letters and complaints, inspections with no violations, the February 18th email, intimidation chronology, and the title company's cooperation. With the board set, Dakota maintained routine. He remained on public right-of-way, added captions, and kept his circle small. Counsel coordinated witness availability and refreshed subpoenas. The aim did not change: show who knew what, when, and how they acted after notice. The week ended with one sentence in Lydia's notebook that summarized the posture cleanly: proceed to trial, prove knowledge, and fix remedies to decision-makers, not families. She also prepared demonstratives mapping actors to actions, so the chronology would read plainly. Trial opened in courtroom 3C with a full gallery: media, lenders, observers, and Ridgeline Heights homeowners, including Sarah Chin. Judge Angela Ramirez reminded the room it was a court, not a forum. Lydia Chen delivered a measured opening. She described the case as theft by paperwork and pointed to the spine of the record: the 1971 deed, decades of tax payments, permit chronology, formal letters, inspection outcomes, and a crucial February 18th internal email acknowledging taxes and planned acceleration, despite likely failure. Defense argued errors belonged to the title company, and that context rebutted intent. The court then heard witnesses in sequence. A title company representative testified to a $45,000 payment connected to Preston Whitmore and explained the internal discomfort with the adverse possession clearance. Inspector Rick Polson described the false complaint pattern he had seen across projects and confirmed no violations. Deputy Torres recapped the public road interactions and a caution to keep matters civil. Grandfather's ledgers entered as exhibits, showing continuity of ownership practice from 1971 forward. Documentary foundations landed cleanly. Who authored, who received, which date stamps controlled. Preston took the stand and, under questioning, contradicted prior testimony on timing and awareness. Cassandra declined to testify, asserting her Fifth Amendment privilege. The record tightened around notice and continuation during sales. After 7 hours, Judge Ramirez took the matter under advisement. In the hallway, homeowners approached Dakota to ask what a plaintiff victory would mean for their families. With Lydia's nod, he repeated his consistent position. Families should keep homes and accountability should reach decision-makers and licensees. Reporters recorded the exchange. The tone remained restrained, focused on documents rather than labels. As counsel packed boxes, the spine stayed visible. Deed, taxes, permits, letters, inspections, email, intimidation timeline, and licensed actors now cooperating with the record. Trial in that day had moved the dispute from allegation to alignment. Cameras could broadcast reactions, but the exhibits would guide the ruling. The room emptied to footsteps and a calendar reminder. A decision would issue soon, then remedies. Everyone waited on the ruling with files boxed and arguments spent. Within 24 hours, Judge Angela Ramirez issued an 18-page ruling. The opening paragraph characterized the defendant's conduct as a calculated scheme to defraud the lawful owner through false adverse possession assertions, bribery, and intentional misrepresentation. The order restored full title to all 47 acres, including the 96 houses constructed on the parcel. It awarded damages of $4.2 million for trespass, emotional distress and loss of use, and attorney's fees of $73,000. Finally, it referred the matter to the U.S. Attorney for potential criminal prosecution. The ruling's structure tracked the proof presented at trial. It cited the 1971 deed and the unbroken chain of tax payments, contrasted the absence of a quiet title judgment with the commencement of sales, and gave weight to the February 18th email as evidence of pre-construction knowledge. It referenced inspection outcomes showing no violations by the titled owner, and described the sequence of letters and complaints as corroborative context. Finally, it identified licensed actors, title personnel and financing participants within the chain, noting that regulatory consequences might follow independent of the civil orders. Public consequences followed the civil order. Ridgeline Capital dissolved. Assets moved to auction under creditor pressure. Preston Whitmore faced a federal indictment. Cassandra Whitmore accepted a plea agreement that imposed 3 years of probation, $500,000 in restitution, and a lifetime ban from Colorado real estate development work. The title company lost its license. Defense counsel of record resigned from his firm to avoid discipline. The case's center of gravity had moved from competing statements to documented conduct and institutional responses. One practical question remained. What happens to the families who bought homes on the land now restored to Dakota Flint? The record showed he had repeatedly separated buyers from the decision-making chain. The answer would turn not on punishment but on structure, how to keep families secure while holding decision-makers responsible. That design was reserved for the next step. The documentary thread remained consistent. Facts, not adjectives. Dates, not speculation. A court had reviewed the exhibits, traced how the project advanced without a judgment, and issued orders matching the paper trail. The dispute's legal chapter now closed. The remedy chapter would begin on a community stage, with documents again at the center and a clear priority: stability for residents and accountability for the actors who engineered the scheme. Deliberately. Remedy moved to the neighborhood. On March 15th, Dakota convened a town hall at Ridgeline Heights. With Lydia present, he announced a practical structure. Transfer all 96 homes into a nonprofit vehicle, the Ridgeline Heights Community Trust, so families would retain their houses at the original prices they had paid. If a buyer had already finished paying, nothing further would be due. If balances remained, payments would continue to the trust at zero interest. Trust funds would cover roads, taxes, and basic services, and launch the William Flint Memorial Scholarship. Reactions were immediate and human: relief, tears, and applause. Sarah Chen stood among those who spoke. The focus remained narrow: keep families housed, maintain services, and place accountability on the decision-makers identified in court. Documentation followed. Council prepared transfer instruments and compliance steps so insurers, tax authorities, and utility districts could align with the trust structure without disruption. Dakota retained 5 acres at the north end with old-growth pines for a cabin. Work reinstatement followed. Family visits resumed on weekends. Channel 9 aired a follow-up segment, From Property Theft to Community Triumph, and the piece won an Emmy for reporting. A child's drawing of Mr. Dakota holding a deed landed on his refrigerator door. The record does not add flourish. It records outcomes: houses secured, governance stabilized, and a scholarship endowed in a grandfather's name. The William Flint Memorial Scholarship provides $10,000 to students in engineering, forestry, or environmental science. Dakota returned to first principles. Receipts matter. Dates matter. Keeping a dispute inside the record rather than inside rumor changes outcomes. This case turned on ledgers that smelled of oil and paper, on electronic receipts, on county indices, and on an email written long before trial. It advanced by discipline more than volume, through counsel's planning, a transcript's patience, and the decision to document rather than spar online. As the trust operated and families settled into ordinary routines, the file's last page carried a simple ethic: protect owners and good faith buyers, root misconduct to courts and regulators, build remedies that stabilize communities, and keep the habit that won the case. Save everything worth proving, then prove it cleanly, carefully, and completely.